Hello, everyone. My name is Kim Smith, and I am a program coordinator for OneOp. I am pleased to welcome you all to today's session, Military Spouse Residency, Relocations, and Tax Considerations. Please note that the slides and resources are available for download on the event page for today's session. We will be covering continuing education information at the end of the webinar, so please stay tuned toward the end if you're interested in continuing education credits or a certificate of attendance. If you have questions for our presenters, please feel free to ask your question in the comments section of YouTube or email them to us at contact@oneop.org. We will gather all questions submitted during the first 2 weeks after this recording is released and publish the answers in a blog post. Thank you for joining us as we continue our partnership with the Defense Department and the U.S. Department of Agriculture to expand the readiness, knowledge, and networks of the professionals supporting our military service members and their families. The views expressed in this presentation do not necessarily reflect the official policy of the Defense Department, USDA, U.S. government, or OneOp. The mention of any entity or product is for informational purposes only. Today, I am pleased to introduce our presenters. Ms. Susan Mitchell is the Executive Director of the Armed Forces Tax Council and the Tax Council in the Office of the General Counsel at the Department of Defense. In this capacity, she serves as the department's lead advisor, representing the DoD on tax and compensation matters in coordination with the Internal Revenue Service, Department of Veterans Affairs, Department of State, Department of Justice, and other components within the Office of the Secretary of Defense. We are also honored to have Ms. Josie Beats as a guest speaker today. She is the Program Manager for the Spouse Education and Career Opportunities Program, supporting and empowering more than 1.1 million military spouses through career exploration, education, training, and employer connections. In this role, she also develops a variety of programs, services, and trainings that are responsive to the needs of service members and their families. She brings over 15 years of experience in the nonprofit and public sectors with a primary focus on supporting military families. Thank you both for joining us today, and at this time, I will hand things over to Ms. Mitchell to unmute and begin today's presentation.
Thank you so much, Kim. I want to move into our learning objectives here, and you can find these objectives online in the slideshow as well as advertised on the event page and in the evaluation after our briefing. I'm going to start with talking about military spouse residency rules, which have changed over the past couple of decades. I always think it's helpful to understanding the Service Members Civil Relief Act by providing a little bit of history about the law. Going back to 1940, Congress passed the Soldiers and Sailors Civil Relief Act, called the SSCRA, to specifically provide protection to service members. The law was updated after the Gulf War in 1991, but remained largely unchanged until December 2003, when President Bush signed into law the Service Members Civil Relief Act, what we know today as the SCRA. This was a complete revision of the former law and provided more protections for service members. It also now provided protection to reservists and members of the National Guard when they were activated under Title X. The SCRA's purpose is to allow service members to focus on their military duties by providing relief from certain civil legal obligations. So what are the protections that are covered by the SCRA? The most common forms of protection and relief are: the law restricts foreclosures and repossession of property, especially for debts incurred before active duty. It allows service members to terminate residential and vehicle leases without penalty if their ability to meet their obligations is materially affected by their military service. It also provides protection from eviction. The law reduces the interest rate on pre-service loans, including mortgages and credit cards, to a maximum of 6%. And it prevents default judgments against service members in civil cases if they are not properly notified and have a chance to defend themselves. The SCRA actually provides quite a few more protections than these. And who is eligible for these protections? All branches of the military. That includes the Army, Marine Corps, Navy, Air Force, Space Force, and Coast Guard members. It includes reservists and National Guard members when they're called to active duty. It includes members of the National Guard component who are mobilized under federal orders for more than 30 consecutive days. It also includes active duty commissioned officers of the Public Health Service, PHS, or the National Oceanic and Atmospheric Administration, NOAA. And in some cases, which we'll talk about, uh, in the SCRA also includes the dependents of service members who may also be eligible for these protections. Notably, the SCRA does not apply to DoD civilians. It doesn't apply to contract employees nor military retirees. And of course, the SCRA also prevents service members from having to pay state taxes on their military income or personal property to any state other than their state of domicile. And that will be our focus today. Originally, the SCRA permitted active duty service members to maintain legal residency in one state while physically stationed in another state. In other words, the law protected, and it still protects, service members from having their military income taxed by both their state of legal residence and the state where they are stationed. In 2009, the Military Spouses Residency Relief Act, the MSRRA, was passed and amended the SCRA to provide similar tax benefits to military spouses. Prior to the MSRRA, service members could maintain their state residency when the military sent them to a new state, but their spouses had to change residency. This oftentimes caused service members and their spouses to fill out multiple state tax forms and sometimes file their taxes as married filing separately when they would otherwise file as married filing jointly. For tax years beginning January 1st, 2018, the Veterans Benefits and Transition Act of 2018 amended the SCRA to allow the spouse of a service member to elect to use the same residence as the service member for state tax purposes, regardless of when they were married. A spouse who made this election was considered to be domiciled in the same state as the service member. For the first time, a spouse did not have to live at some point during the marriage in the same state where the service member had established residency in order to claim the same state of residency as the service member. Note that the other conditions of the MSRRA remained to include being present with the service member in compliance with military orders when that state is not the spouse's domicile. Note also that the MSRRA requirement that the military spouse be in the new state solely to reside with the service member pursuant to PCS orders is still required to claim the SCRA tax benefits. In 2022, the Veterans Auto and Education Improvement Act further amended the SCRA to clarify that for purposes of taxation, service members and their spouses may now elect to use one of three states. the residence or domicile of the spouse, the residence or domicile of the military member, or the permanent duty station of the service member, rather than just the state where the service member and the spouse are residing together. It may be important to point out that spouses actually have broader protection than service members. The SCRA says that military members can use their state of legal residence for taxation of their military income, but spouses may use their state of legal residence for taxation of all of their income. For example, that means that a military spouse who drives for, say, Uber Eats at their duty station can attribute that income to their state of legal residence. But if a military member drives for Uber Eats at their duty station, they'll have to attribute that income to the state where they are stationed and driving for Uber Eats. This creates a situation where the service member needs to file in two states, but the military spouse is only filing in one state. Just a quick note also, all of these amendments actually are amendments to the SCRA, not to the MSRRA. The timeline of changes PDF that you see on the slide has a linked QR code. It also is listed under resources on the event page. And if I would encourage you to save this particular slide and refer back to it. Let's talk briefly about the terms domicile and residency, which can absolutely be confusing. Domicile is a legal term that is also sometimes referred to as legal residency, and that's part of the confusion over these terms. So, in other words, there is a big difference between residency and legal residency. Under the concept on which the state tax system is based, each person can only have one domicile at a time. Domicile is the state where a person has his or her true and permanent home. For military members, it is the place to which the member intends to return at the conclusion of their military service. What the SCRA does is prevent a state from creating a presumption that an active duty military member becomes domiciled in that state simply because they are stationed there. The member may choose to become domiciled in that state, but cannot be forced to. He or she can retain their old domicile throughout their military career. Contrary to a popular misconception, however, the SCRA does not give a military member the unlimited right to choose any state as a new domicile. For example, they could not become domiciled in the state of Texas if they are not stationed there or enter into the military from there. Residency, on the other hand, is simply the place you live or the address a military family is currently using. For example, a military spouse may be domiciled in Virginia because that is where all of the military spouses' legal paperwork originates, but physically lives or has a residency in North Carolina. Residency changes based on where an individual is physically living. Let me mention the term home of record, which is often confused with domicile and state of legal residence. Home of record is not necessarily your domicile. Instead, it's merely the military term for the address listed when the service member entered active duty. The primary purpose of home of record is to determine military benefits such as travel entitlements once the service member is separated from the military. Other than that, the term home of record is usually a meaningless term outside of the military, and it has no effect on where an individual votes, pays taxes, registers their vehicles, or receives any of the other privileges of state residency. So let me make sure I'm on the correct slide here. I think it's always helpful to discuss proof of domicile. Proof may be required if an individual attempts to take advantage of benefits offered to persons domiciled in that state, or if they claim a different domicile for the purpose of avoiding taxes. Indicators of domicile include where you are registered to vote, which state issued your driver's license, where your car is registered, where you file your state income tax return, what state is listed in your will, what you've attempted or where you've attempted to establish a permanent address, for instance, the home state when entering the military or your family's home. Also, the total length of time that you've been present in the state, whether you've notified your old state's taxing authorities that you are no longer domiciled in that state, and the state where you own property. This list is not all inclusive, but it does provide some indicators of domicile that should be considered. Although no one factor is controlling, each of these factors helps to indicate a person's intent to remain in a place indefinitely. So accomplishing some or all of these acts may provide enough evidence for a state agency to accept the individual's new state of residency. Here are a couple of tips for your clients. Don't get a driver's license just because it may be easier than renewing in your home state, but do get a local driver's license if your state law requires it. Don't sign an affidavit that you are a local area resident merely because it saves you a few $100s on your property taxes. Try to stick to one state in all of your actions whenever possible. To change your domicile, there are some requirements. First, physical presence in the new state is required to make a change. Second, you must have a present intent to remain in the state indefinitely. And third, a person must abandon ties with their former state of residence. Once an individual meets these three requirements, he or she is domiciled in a state, and that state will be his or her state of legal residence. Under the SCRA, something unique to service members, they retain the state they claimed when they entered active duty as their state of legal residence unless they take affirmative steps to change their state of legal residence. To demonstrate the intent to change their legal residence, service members can, for example, surrender their old driver's licenses. They could not vote in their old state's elections. They could deregister their vehicle in their old state, and they can write a letter to their state income tax authorities informing them that they are no longer a legal residence of the old a resident of the old state. It's important to note that merely changing their state of legal residence with the military finance office does not legally change their state of legal residence. There are, I think I may have gone too far. Let me see. There are some nuances that people should know about the SCRA provisions regarding residency. For instance, the SCRA says that military members can use their state of legal residence for taxation of their military income, but spouses may use their state of legal residence for taxation of all of their income. That creates a situation where the service member may need to file in two states if the service member has a side job, but the military spouse is only filing in one state. Also, be aware that to take advantage of the benefits of the SCRA residency provisions, military spouses are required to be physically located with the service member pursuant to the service member's military orders. A spouse who is geographically separated from their active duty service member loses the residency portions of the law in most situations. When you look at the text of the law, if the military orders allow spouses to accompany the service member, but instead the spouse stays behind, the Department of Justice has said that it will be hard to argue that the spouse gets favorable tax treatment. It's a different case when the family is not able to come with the service member or is sent back to a former residence. DOJ has not had an opportunity to litigate this, but they would say that the risk of litigation is less in a situation where the spouse is not able to accompany the spouse to the military spouse to a duty assignment. Ultimately, be aware that DOJ is conservative in interpreting the SCRA. If there is a state that wants to tax a spouse, DOJ will look at the various factors involved to determine what their risk in litigating the case is. And if it's risky, meaning if there's a likelihood that DOJ will lose, they will not take the case, and the spouse will be left to fight the state taxing authorities on their own if a state has audited the spouse. Lastly, just be aware that there may be apparent conflicts with state laws related to residency. If you remember, a state can pass any law and hold itself to any standard that it wants to, but on a case-by-case basis, the state must follow the SCRA. In other words, the SCRA will govern in situations where an individual is covered by federal law. Only if a state chooses not to follow the correct law do we see issues. Again, in practice, though, state laws usually apply more broadly instead of focusing on individuals to whom the SCRA specifically applies to. Okay, here is an example we can work through. We have Joe, the service member, and his spouse and children who are stationed in Georgia. Joe receives orders to move to North Dakota for 3 years, and incidentally, Joe is domiciled in Texas. Kathy, Joe's spouse, wants to remain in Georgia with their high school children so that they can graduate with friends in their established neighborhood. So, where should Joe and Kathy file a tax return? Texas does not have a state income tax, so Joe would likely want to choose Texas as his state of residency. Joe would only file in North Dakota if he had a civilian job in that state. For instance, if Joe worked at a local hardware store in North Dakota on the weekends, he would file as a North Dakota non-resident and only report income from that W-2. Under the 2018 amendment, Kathy would have been obligated to pay taxes to Georgia on income earned in that state during the years Joe is stationed in North Dakota because she is residing in Georgia and is also no longer there with the service member due to military orders. Now, under current law, Kathy can choose to file in Georgia, where she currently resides, in Texas, her service member's domicile, or in North Dakota, the service member's permanent duty station. Assuming Joe and Kathy are filing jointly, they should file in the same state, likely in Texas, where there is no state income tax. What if Kathy and Joe's children are in college rather than in high school, and they would like to maintain Georgia residency so that they can receive in-state tuition? In that case, Joe and Kathy would file in two different states and they would file married filings separately. This is so that Kathy can maintain Georgia as her residence and continue paying in-state tuition, and Joe would no longer have the option of filing in Georgia because he no longer resides there. This is not the ideal situation, as it's using the SCRA as both a sword and a shield, as DOJ would describe it. However, filing separately is the least risky solution in this case. Here's another example which helps describe a unique situation. We have a dual military couple stationed in Virginia. Jake is domiciled in Texas, while Sarah is domiciled in Wyoming. Jake retires and moves to Montana to set up their eventual home together. Sarah stays behind in Virginia to continue serving. So, where should Jake and Sarah file their tax year 2025 return when they file in 2026? As the remaining service member in the relationship, Sarah will likely choose to file a tax return where she is domiciled in Wyoming rather than where she is stationed in Virginia, since Wyoming has no state income tax. Once Jake retires as a service member, he is considered a military spouse. As such, he may choose to file his taxes in one of three states: in Montana, where he resides currently, in Wyoming, the residence or domicile of his service member spouse, or in Virginia, the permanent duty station of his service member spouse. Although he has likely claimed Texas since he came into the military, Jake lost his residency in Texas the day after he retired, since Texas was only his residence due to his status as an active duty service member, assuming Sarah did not also have her residency in Texas. Here are some key takeaways regarding spouse residency for tax purposes under the SCRA. It was the Veterans Auto and Education Improvement Act of 2022 that most recently amended the SCRA. Now, a military spouse can choose one of the following as long as they are solely with the service member in compliance with the service member's orders: the service member's residence or domicile, the spouse's residence or domicile, or the permanent duty station of the service member. Remember also that domicile does not mean home of record. Even though a service member's home of record automatically becomes their domicile for tax purposes when they enter the military, the service member may take steps to change their domicile. If they successfully change their domicile to another state, they still retain their original home of record, which again has no effect on where they file their tax return. Let's talk about tax considerations when moving or PCSing, something that undoubtedly affects every service member and military spouse. Before moving, service members and their spouses are advised to check the residency rules for the state where they are moving to. Some states consider an individual a full year resident if they're present in the state for at least 183 days. In other situations, service members and their spouses will file as non-residents or part-year residents. If they're filing two part-year resident returns, they should also check the rules for each state on what income to report, since income from interest, dividends, and pensions is usually considered to be from the state of residence. When reporting income, you can advise service members to keep in mind that some states will have them report their income from all sources, just as a full year resident does. Then, after the tax is calculated, this amount will be reduced based on the income they made as a resident compared to their total income. Other states will have them divide the income between states before calculating the tax. Some states offer a part year return, meaning that they only claimed residence for part of the year, while others have you fill out a regular or non-resident return after the move has occurred. Each state has its own rules for who must file, and also be aware that some states require a return even if you owe no tax there. So, 8 states currently have no state income tax whatsoever. Those states include Alaska, Florida, Nevada, South Dakota, Tennessee, Texas, Washington, and Wyoming. The ninth state on the list, New Hampshire, only taxes interest and dividend income. If an individual lives in one state and works in another, they may also be able to take advantage of reciprocal state tax agreements. This is made possible when two or more states have an agreement to exempt the income that's earned by non-residents from a nearby state. For example, with a state income tax reciprocity agreement, a taxpayer who lives in Indiana but works in Kentucky will only pay income taxes to their state of residency, in this case, Indiana. In most cases, if there's a reciprocal state tax agreement, they can fill out a withholding exemption request form for the non-resident state and submit it to their employer. That way, their employer will only withhold state income tax for the correct state. They'll likely file a part-year resident return in both states in that case. Also, if you have a service member client renting out property in the state that they move from, even if they establish permanent residency in the new state, they will likely have to report their rental income and expenses on both their old state and their new state income tax returns. However, the new state will most likely allow a credit for the taxes paid to the old state because of the rental property income. For many of these issues, I always recommend that financial advisors advise clients to consult with an independent tax advisor because, as you see, it can get complicated. For tax assistance, I would also advise you to encourage your clients to leverage Military One Source's MilTax, which is the free tax software for service members. To recap, before we move on, I'll remind folks that each state has its own unique rules for who must file, which form to use, whether it be a resident tax form or a non-resident tax form. And there are rules about which income to report. Bottom line, every state is different. Most people are aware that there are several states with no state income tax, where I'm certain many service members are able to eventually establish domicile in. Your clients should also be aware that they may need to file tax returns in multiple states, and they should also know whether they are impacted by reciprocal state tax agreements for employees who commute across state lines. Finally, there may be a need for service members to file in multiple um, uh, states, not only because of being a part-year resident in them, but especially if they qualify for credits or deductions of tax that has been withheld or paid to another state. It's important to know that military spouses have access to free, trusted resources to help them make these informed and unbiased decisions when navigating taxes. These military spouses are not alone. Okay, next, let's talk briefly about how domicile and residency are affected where military families may choose to file for divorce. Although individuals can usually get married anywhere in the United States, no matter where they live, that's not true in the case of divorce. All states have residency requirements that they must meet before individuals may get a divorce in their courts. Usually, but not always, the couple must have lived in the state for a certain period of time just before they file the divorce papers. But several states have their own twists on the basic rules. Divorce residency requirements were typically meant to prevent forum shopping or filing for divorce in a state where they don't normally live, just in order to take advantage of laws that might be more favorable to them. But these requirements can also impact spouses who've recently moved to another state as part of the process of separating and would prefer to have their divorce case proceed in the courts where they currently live. Before a court can issue a court order for a divorce to military members or non-military spouses, it must have jurisdiction. And when individuals meet the residency requirement to get a divorce, that means that a court in their state has jurisdiction or legal authority to end the marriage by issuing a divorce judgment or decree. This authority is called subject matter jurisdiction. But there's another kind of jurisdiction as well, and that's personal jurisdiction. Basically, a court must have personal jurisdiction over someone before it may issue orders affecting that person. So, what does this mean in the context of divorce? Say that you've separated from your spouse, moved to another state, and filed for divorce in that state after you've met the state residency requirements. But your spouse might never have lived in that state or owned property there. Depending on the state's rules for personal jurisdiction and actions your spouse takes, that could mean that the court won't be able to divide your marital property in the divorce or order your spouse to pay alimony. Also, more than half of all states require at least 6 months, 180 days, of verified residency in order to file for divorce. There are many other jurisdictions that require only 60 or 90 days. And why does jurisdiction matter? Well, because different states have different laws on the division of military pensions, different rules on alimony, and different rules on child custody preferences. There are some extra residency rules in military specific divorces. One of the first hurdles in a military divorce is determining where to file. Civilian couples typically file for divorce in the state where they live. However, because of the PCS moves that military families endure, residency is less straightforward for our military families. Most states allow military members or their spouses to file for divorce in the state where the service member is stationed, where the service member claims legal residency, or where the spouse resides. These options can be both a benefit and a complication. So, couples are advised to weigh factors like state specific divorce laws, property division rules, and tax implications when choosing a jurisdiction where to file for divorce. Both state and federal laws govern military divorce. For example, federal laws may determine where couples go to court or how to divide military benefits. However, state laws may affect alimony orders and spousal support orders. Also, state courts determine divorce terms, including property division, child custody, and child support. The law that typically applies to child custody when parents live in different states or countries is the Uniform Child Custody Jurisdiction and Enforcement Act, the UCCJEA. According to this law, jurisdiction over a child is in the state where the child legally resides and where they have been physically located for the previous 6 months. In other words, a state having jurisdiction over a service member does not necessarily mean that it has jurisdiction over child custody. On the other hand, federal law, specifically the Uniformed Services Former Spouses Protection Act, says that the state of legal residence of the military member always has the power to divide the military pension in a divorce. Lastly, filing in the states from overseas is preferable to trying to get a foreign divorce, even though the foreign divorce might seem attractive if you have a service member stationed where divorce is easy or inexpensive. But the military won't honor a pension division order from a foreign country, and it's hard to know for sure that the divorce judgment itself will be respected when the couple return to the States. Let's talk about how the SCRA plays into all of this. The SCRA allows active duty service members to request a delay in the proceedings. It's called a stay in the proceedings for a divorce or spousal support, custody, child support, property division, and military pension division. And that's if their duties prevent them from participating in or responding to the court action. Incidentally, this is true for other types of non-criminal court cases as well. The initial stay is for at least 90 days, and the court can grant extensions after 90 days, but the proceeding can't be postponed indefinitely. The purpose of the stay or the delay is simply to delay the court action as long as the military member's duties interfere with their participation in the proceedings. The stay can potentially last for the duration of the service member's deployment plus an additional 60 days. And here are some takeaways regarding divorce and domicile. Recall that all states have residency requirements for divorce to include military members. While that makes, or what makes military divorce unique is that military families may have several choices where they can file for divorce. Also unique to military divorces is that both state and federal laws govern. And finally, under the SCRA, military members can request postponement of court proceedings if they can successfully argue that their service has a material effect on their ability to defend against the litigation. So at this time, I will turn it back to Josie to address military spouse employment topics. Josie?
Thank you, Susan. It's so good to be with you today to talk about some of the implications on military spouse employment that have come from the SCRA, as well as some of the other resources that we offer at the DoD to help support military spouses through their career journeys. First, I want to talk about license portability. So this is the ability to move your occupational or professional license from one place to another as you go through those military moves, those PCSs, from one state to another. A 2023 amendment to the SCRA indicated or allowed spouses to move their license from one state to another when military orders force them to go to a new state. That new state should consider valid that license at a similar scope of practice in that discipline. And that should remain for the duration of the military orders. You know, this is an evolving area of licensing and the law. And so I would encourage you to visit the website that's listed in this presentation and linked to, because that is going to give you more information on the individual spouse's circumstances. It's also worth mentioning, we'll talk about it a little bit later on the next slide, but there are many interstate compacts for licensed professions that already allow spouses to transfer those professional license or to practice under those licenses in a new state. This is a really crucial part of support for our military families. Spouses who are within 12 months of that military move, that PCS, suffer from higher unemployment rates than spouses writ large. And so eliminating barriers to licensing is one of the most important things we can do to continue that military spouse career journey. A little bit about the Spouse Education and Career Opportunities program that we manage out of the Military Community and Family Policy Office in the Office of the Secretary of Defense. We provide supportive services to active duty, reserve, and National Guard spouses, really helping spouses do three things. We help them find a job through connections to employers through our Military Spouse Employment Partnership. That is a group of more than 950 employers across the country and around the world who have raised their hand to hire military spouse talent. They provide a job board of over 400,000 jobs that spouses have access to in order to find that job opportunity. We also offer career advice to military spouses through our career coaches. This is an individualized, unique experience to each spouse to work one-on-one with a career coach who will specifically work with their unique circumstance to provide career advice and direction, whether they are just starting out in an entry-level job, whether they are mid-career, even if they're more senior, but maybe undergoing that PCS where they just need a little bit of guidance on the next steps to take. And then finally, we help spouses explore education. We do this primarily through our My Career Advancement Account program that provides up to $4,000 to eligible spouses for training, certification, and licensure. It can also go towards courses towards an associate's degree. That program is limited by the rank of their service member spouse, but was recently expanded. So all enlisted ranks are eligible. Officer O1 to O3s and W1 to W3s are eligible for that program. And we see incredible outcomes of that in courses that spouses are taking and associate degrees that they are moving towards. We do all of that from our office in the Office of the Secretary of Defense. We are a fully virtual program, so we meet spouses where they are. 74% of military families live off the installation, and so that virtual service really provides that individualized or ability to reach spouses where they are. Licensure reimbursement. Each service offers reimbursement of certain licensing costs through a PCS move or that military move. It's slightly different for each service. And so I would encourage you to go to this link and investigate. We've got it listed there by each military service. And so you can click through in that. The most important part of this is not just the licensure reimbursement that has existed for a couple of years, but it was recently expanded to include reimbursement for certain business moving costs for spouses who may be entrepreneurs and need help with moving or expenses related to moving their business from one jurisdiction to another. So a really great expansion of that reimbursement opportunity. I am lucky enough that I get to see the number of spouses that apply for that reimbursement, and it is too low. And so make sure that the spouses that you serve or you yourself are taking advantage of that reimbursement. A lot of spouses are interested in federal employment for a multitude of different reasons. Frequently you find yourself on installations where federal employment is the most viable option. Federal employment is highly sought after. And so there are really 3 different ways that spouses can get into the federal government. You can see them at this link. But in summary, the first is the non-competitive appointment authority for military spouses. That is available across the federal government in every agency, and it allows a military spouse to be non-competitively appointed to a position. There are really no positions that are exempted from that. It is dependent on the agency and the hiring manager being aware of that non-competitive appointment authority. In the Department of Defense specifically, we have something called military spouse preference that is available only for DoD civilian positions and is really tied to that military move, that PCS, as we say, and has some limitations on it with regard to timing. And then finally, the last way spouses can come into the federal government is through a direct hire authority. A direct hire authority isn't specific to spouses, but it is an easier pathway into government service than the competitive process. There are many jobs that are direct hire. One of my favorites that are direct hire is veterinarian. So if you're a veterinarian, you can be direct hired throughout the federal government. But each agency has its own direct hire authorities for certain series and grades. And so a little bit of investigation does have to happen on that. And then finally, I wanted to make sure that we flag the exemption for military and foreign service spouses on federal agency return to office plans. This is this came out of some executive orders here in 2025 that required federal employees to return to office. But in recognition of the fact that many military spouses have been granted remote roles throughout the federal government, those military spouses are exempted from those return to office plans. And you can get more information on that at the Chico Council website that's linked to on this slide. I would encourage you to go there, as well as to your agency if you have more questions about the return to office plan. With that, I am going to turn it back over to Kim to close us out today.
Thank you, Ms. Mitchell and Ms. Beats, for such a comprehensive presentation today. It was full of valuable resources. And thank you to our viewers. If you are watching this recording and have questions for our presenters, please feel free to comment in YouTube or email them to us at contact@oneop.org. We will gather all questions submitted during the first 2 weeks after this recording is released and publish the answers in a blog post. Be sure to email us your questions before June 18th and return to the event page afterward to see the responses. There have been a lot of great resources linked throughout today's presentation. As a reminder, you can download a PDF of the slides as well as all of the resources shared on the webinar event page. I'm going to share the continuing education information with you all, but before I do, I'd like to highlight the DoD's online resources designed for personal financial managers and counselors. These tools are available on the FinRed and MilSpouse Money Mission websites, the Sense mobile app, tailored e-newsletters, and social media platforms. Explore valuable resources such as the Financial Wellbeing Assessment, conversation cards, media kits, spending plan worksheets, the Net Worth Tracker, and more. We'd also like to invite you to an upcoming webinar, Understanding Financial Uncertainty and Military Suicide Risk, which will be held on Wednesday, July 16th from 11 a.m. to 12:30 p.m. Eastern Time. This session will recognize the critical link between financial distress and suicide risk among service members and their families. Explore best practices for ethical and supportive financial counseling and resources for crisis intervention. Navigate to the event page listed on this slide to RSVP. We also want to invite you to join us for the Academy taking place this year in August and September. The Academy is an annual event bringing together military family service providers from multiple disciplines to address a topic important to the military family readiness system. This year, we will be bringing together experts and professionals like yourself to address key challenges facing military youth well-being. Over the course of 6 weeks, OneOp will deliver a series of professional development opportunities, including an expert panel discussion and 3 webinars. The panel discussion will discuss how military family service providers across the military family readiness system can support the well-being of military youth. The webinars will equip military family service providers with evidence-based strategies to support adolescent well-being through transitions, create inclusive programming, and strengthen protective factors for military-connected youth. A variety of continuing education credits from many different professional credentialing agencies will be available for Academy events. For more information and to register, please visit the Academy page on the OneOp website. Our current session is approved for 1 continuing education credit from the organizations listed on this slide. To complete the webinar evaluation and request CE credits, you can navigate to the event page and click on the purple Continuing Education button or scan the QR code listed on this slide. While completing the webinar evaluation, we would sincerely appreciate specific suggestions for future webinar topics as it relates to your work with service members. At the end of the evaluation, you will choose the correct link for your accreditation. Depending on your CE type, you may be directed to a post-test, which you must pass with 80% or higher in order to receive a certificate of completion by email. Some email providers will direct certificates to your spam folder, so please check there if you have not received the certificate within 48 hours. If you have any questions, please email us at the email listed on the slide, ce@oneop.org. To connect with us, go to oneop.org to access free CE opportunities, blogs, and other resources. We invite you to sign up for our OneOp mailing list and to follow OneOp on social media, including Facebook, LinkedIn, and YouTube for daily resources and OneOp programming updates. A huge thank you again to our presenters, Ms. Mitchell and Ms. Beats, for sharing their expertise and valuable insights. We appreciate your time and contributions. And thank you to our viewers. Be sure to explore all the resources on the event page and stay connected for future sessions. We look